I'd like to call the Planning and Zoning Commission meeting to order at this time. Let us all rise to pledge allegiance to the flag. Let's have the roll call.
Chairman Severs,
Present.
Vice Chairman Spidell, Secretary Richardson,
Present.
Member Grant,
Present.
Member Rice,
Here.
Member Parrish, Member Porter,
Here.
Alternate Member Riley, Alternate Member Childs.
Here.
As far as the regular membership, we have one person that has been approved by council on a leave for the month of April. Member Riley, Alden Member Riley, I would designate you to serve tonight in a voting capacity. As you may know, we've changed the rules so that even those alternates that are here still can participate in the discussion, provide their input. However, they cannot vote. But I think if you're going to come here, you should be allowed to participate and give us your wisdom as such. So, Member Riley, you will be serving as a voting member. So we do obviously have a quorum. As far as approval of the minutes of March 17th, are there any additions and or corrections to the minutes? Not hearing any, is there a motion to approve?
I move we approve the minutes of March 17th, 2021.
Second?
I second, sir.
All those in favor, please say yes.
Yes.
Yes. Those opposed, no. At this time, I'd like to go ahead and do the attorney do the notice provisions for the meeting tonight.
In order to help prevent the spread of the COVID-19 coronavirus and to comply with all local, state, and federal laws and guidelines regarding social distancing rules, designated seating shall be provided for the public at Planning and Zoning Commission and other city board meetings. Individual speakers shall, when directed to do so, be given the opportunity to speak on agenda items during the meetings in accordance with the City of Titusville policies and Resolution Number 36-2020. No tripods, easels, props, or other demonstrative aids shall be brought into public meetings of Planning and Zoning Commission and city boards. Speakers are permitted to have a sign with them during their designated speaking time, provided that the sign is held by the speaker and is to be removed at the conclusion of their speaking time. Speakers who appear in person will be subject to screening for symptoms of COVID-19, and any persons exhibiting any symptoms of COVID-19 will not be permitted to enter City Hall or public meetings of Planning and Zoning Commission and city boards. As an additional method for public participation, the public may submit written comments via email to planning@titusville.com or by regular mail to Planning and Zoning Commission's attention at City Hall, 555 South Washington Avenue, Titusville, Florida, 32796. Written comments must be received by 12 noon prior to the start of the meeting and include the sender's name, address, and subject line must specify the agenda item being addressed. All comments will be disseminated to the Planning and Zoning Commission and members and made a part of the public record prior to any action being taken. All persons who anticipate speaking on any public hearing item must fill out an oath card to be heard on that agenda item and sign the oath contained thereon. These cards are located at the table near the entrance to the council chamber or may be obtained from the recording secretary. This meeting will be conducted in accordance to the procedures adopted in Resolution Number 24-1997. Those speaking in favor of a request will be heard first, those opposed will be heard second, and those who wish to make a public comment on the item will speak third. The applicant may make a brief rebuttal if necessary. A representative from either side, for or against, may cross-examine a witness. Anyone who speaks is considered a witness. If you have photographs, sketches, or documents that you desire for the commission to consider, they must be submitted into evidence and will be retained by the city. Please submit such exhibits to the recording secretary.
Thank you, counsel. As far as the quasi-judicial confirmation procedures, none of the items we have on the agenda are quasi-judicial in nature. On the contrary, they're legislative natures for drafting ordinances and our comments upon those. There's no consent agenda items. There's no old business items. New business, item A, outdoor area of seating. Staff, would you like to give a presentation?
So we have a presentation tonight only for the brew pubs. The outdoor entertainment is, we don't have a presentation for you.
Okay, okay. Any questions at this stage by, yes, Member Spardell?
Oh, I'm so sorry.
That's all right. Why don't we wait until after we end the public hearing? Do we have any cards on this item?
Yes, sir.
Okay, go ahead and call them.
Ed Gerard.
Now I'm on. Thank you. Again, good evening, Commissioners. My name's Theodore Garada. Please call me Ted. I've come here tonight to ask a few questions. I'm neither in favor or disfavor of your proposed ordinance. I do have those questions. Just for background, I'm a certified planner with the American Institute of Certified Planners, a member of the American Planning Association. I have over 35 years of experience in administrative requirements, both in planning, zoning, code enforcement, and the short of it is I've been around the block a few times regarding matters like this. My questions are pointed at the fact that in reading your ordinance, it doesn't commingle too well with your noise ordinance. And I read through your noise ordinance. So the first question, in regard to the adoption of such an ordinance where a new business would presumably come forth with a conditional use and request permission, significantly asking that to be tailored for the location as your conditional uses typically are, subject to whatever that environment may warrant. Your proposed ordinance appears to be targeting areas where you'd have a conflict in land uses, residential against commercial, where these outdoor noise generations, amplified sounds would be a nuisance. I'm not sure I understand what that conditional use is doing to set aside your noise ordinance. Conversely, if you did have an approved conditional use, would that in a de facto manner exempt the applicant for that, and upon approval, allow it to generate noise beyond your noise ordinance? So the twofold question is, does your noise ordinance maintain its authority regardless of the conditional use, or does the conditional use have an overriding, as there is I read in administrative requirements, your city manager can grant an exception, special events and those kind of matters typically warrant that. Would that happen? Would you be able to set aside your requirement for noise generation exceeding the decibel limits by the approval of conditional use, or would you not?
Okay.
That's one question. I have a few more.
Okay, go ahead.
The second question is that in reading your ordinance as proposed, it appears to approach only those businesses that would be licensed for food and beverage sales. Combined with that they would have amplified sound, amplification creating a larger, more volume of sound. Sound pressures would be measured. So if you did not have a licensed facility that was serving food and beverages or both and or outside seating, it simply had the generation of sound amplified. That example given would be drive-through, where you have a restaurant abutting a residential neighborhood. Based on my experience, would say I'm sure your code enforcement staff or the city or both have received complaints from noise generated at restaurants that serve an outdoor amplified sound, but they don't have outdoor seating and they have amplified sound, but it's not entertainment, it's business. So I would presume your noise ordinance would still be in effect and that code enforcement for such activities that would exceed the limits or be annoying would be enforceable. And in that regard, I'm trying to come to grips with why a noise generation from an establishment that has outdoor seating by conditional use is extraordinary to the similar conditions that warrant enforcement potentially, or certainly annoyance, where you have amplified sound. I can use a good example from where I live, and I'm pretty sure the city's aware of it. Bless the Titus Landing and the Harley Davidson dealership. I hope they're doing really well. And to attract business, they do pretty good at making noise. If noise is loud music, you can hear for blocks around. Without guessing, I'm pretty factual. I believe I would stand on the property boundary and find an exceedance of noise generated by amplified sound, but there's no outdoor seating. They're not serving food. So this facility would continue in its operation. Perhaps it would be annoying to some, or has been annoying to some, but there'd be no extraordinary measure by which they would have to come to public hearing and present evidence supporting why they have a right to do this. But there's an extraordinary circumstance. The conditions warrant that. You would all examine it and perhaps say build a wall or put a sound buffer up or don't have more than this much amplification, move your speakers in a different direction, all those sundry matters that you typically consider in a conditional use. So the question is, why is this singled out for that effect? Abatement of problems before they happen with a conditional use format, but you haven't effectively done anything for all those other circumstances. Restaurants, outdoor speakers, and the like. So 3 questions. And if you can help me with that, I'd sure appreciate it.
Okay, staff, do you, or city attorney's office, you want to respond?
Good evening, sir.
I think it would be better that you respond than members of the commission.
I've got a couple pieces of information that might help. The first is that the Harley Davidson events are permitted under the special events permit process, so it's a little different than from how this ordinance would impact day-to-day operations of uses. And then whether the CUP could override the noise ordinance, I think it would be conflicting if you approved a conditional use permit that would contradict your code. So I don't think that the intent is to allow CUPs that would extend the noise, allow noise past the noise ordinance. But I was curious because you mentioned that there were some inconsistencies, and I wanted to make sure that I understood the inconsistencies. Was it the time?
No, the inconsistency would be, and I appreciate the response that a CUP would not negate your noise ordinance. So if the premise of the ordinance is to protect the property right residential against the format of that, what benefit has the CUP done if in fact the amplified sound exceeds your noise ordinance? Or conversely, an establishment is in operation lawfully, approved by conditional use, turns the amplifier up too loud, code enforcement arrives, does its measurement, and says you have to turn it down. What benefit did the conditional use have to that? Is it the seating that's outside, weather conditions? Is it public assembly in a facility that might not be capable of holding it? Street parties come. Sidewalk impedance in areas where people spill over from the private property in public areas, where in the conditional use perhaps you can say you're not in the right location or don't have the facilities to provide for that public assembly beyond your property boundary. And so rather than create a problem, we just want to approve you in your request. You need to find a more beneficial site, one that has larger areas out in the woods, so to speak. So I'm not sure I see what the conditional use format is serving if it doesn't have the ability to negate your noise ordinance, provide, as you said, a special event. If it's formatted in that regard, I certainly would understand it that you're using a kind of a layer cake approach. You're looking at a site, establishing it's a proper site, it's got the right facilities to support the request for outdoor seating and amplified sound. But in the event that it's going to make a little bit too much noise, investment in the real estate, the investment in capital for a business to buy amplification equipment and sound and all those things that go on, leaves himself saying, I do all of this and it doesn't matter, I could still be given an ordinance violation. I'm not protected. On the other side, if I am protected, I could understand it. If you could exempt the noise ordinance because you've approved this particular conditional use. And it doesn't make any sense to me that you would put a proprietor in a business. And I think the more interesting feature is your non-conforming use provision. I was reading through those and I looked at the establishments I know that have outdoor seating, amplified sound, providing for entertainment. So, okay, this facility has TV speakers on the outside that are turned up enough you can hear the TV over the noise of US 1. But I'm going to have to request a conditional use to be able to do this. Now, according to nonconformity uses, if I'm already in existence and you require me to go do this if I was new, conversely, you can't come back and say you have to do it now after the fact. You were already established. And that's traditional. Where the bothersome part comes is, what if the proprietor enlarges the outdoor seating by 10 seats? Well, let's just say the outdoor seating has 20 seats and they enlarge it by 21 seats. They doubled the seating. According to what your non-conforming use provisions would state, that's expanding your non-conforming use. You're providing greater outdoor seating. So now retroactively, you have to come request the condition for the 41 seats. You had a right to keep 20, make noise, get a citation if you violate the ordinance, and stay in this kind of a world of the gray grandfathering rule. But if I try to expand,
I'd rather let's just focus upon the noise issue, not non-conforming and all of those nuances.
that's a very important nuance, I'm afraid.
Well, let's stay with, I think staff has answered your question.
Okay.
Attorney, do you have any, as I understand staff, you would say a CUP would not override the no noise code?
Correct.
Correct, okay.
And I would
That's the
agree
long
with,
and short of it.
I would agree with staff's response to the questions that have been raised thus far. I'd like to also elaborate on the city's presentation on this item. 9A, outdoor areas of seating, is in response to a prior discussion that this commission had in regards to the subsequent item on your agenda, the Brewery Ordinance. And if you go to page 22 of your agenda packet, you'll see the minutes from the regular meeting of January 20th, where this commission discussed several issues that they found to be problematic with the presented brewery ordinance that you had at that meeting. In the minutes, you see some of the issues include the conditional use permit. I think that's an important topic for discussion tonight between the commission and members of the audience, the public, who may have an opinion to voice on that. Some of the other changes you'll see, of course, are redlined throughout the ordinance, but I think that it's important for the city to make it clear that this ordinance hasn't been advertised yet, because we are responding to the recommendation of this commission and invited the public in order to get better direction on how we could formulate the regulations on outdoor areas of seating. And one thing that I find particularly interesting for discussion would be that there's no definition for this code section. Right, the way that the outdoor areas of seating code is currently written, there's an opportunity to clarify what that is. I think it's important to note that the outdoor areas of seating currently is a regulation for only the downtown mixed use zoning district. And the proposal from this commission was to expand it to the entire city. And so that's what you see on page 12 of your agenda. That's where the zoning districts are changed, as well as some of the conditions that were applicable only to the DMU. I think that there's a difference in application between when you look at outdoor areas of seating on the sidewalk compared to outdoor areas of seating that are part of a permanent structure, like Shiloh's or El Leoncito has those outdoor eating areas that are defined and can't really be expanded except for a change to the site plan, where downtown mixed use properties are expanding their use by going to the sidewalk, literally. And I think that there's room for making a definition that would capture the things that are intended but for discussion by this commission. When you previously discussed what you had in mind, I think also captured entertainment, which I think is broader than just sitting outside. So those are some of the things that we would like to hear input from both the community and the commission members.
Okay, thank you. Member Richardson, did you have a comment or
Yes,
questions?
but I pressed my button before we called any cards.
Oh, excuse me.
I've noticed some no changes in this ordinance. And that is about the distance between the outdoor seating and the residential areas. In the motion, it says, it suggests 125 feet in West Melbourne. It's not included in this ordinance. And the lack of the staff report tells me not much has been done in 4 months. And I've gotten calls today from the lady that owns Durango's. I think her first name was, can't remember. It starts with a J. And I've read the input from Laura Lee Thompson that we table the motion, table the action. And since there was no staff report, and I don't see many changes to the ordinance, I'm not in favor of passing this tonight or making any recommendations tonight because I don't see the changes. There's Laura Lee coming in.
Well, let's get the public input. We thank you, sir, for
Well,
your
I appreciate
input.
you have a 3-minute time limit, so may I speak again on this? I still have some questions that are going to generate as you respond to questions. So
Well,
am I allowed to speak again?
Fortunately for you, I didn't turn on the clock.
Fortunately for you, Attorney. Well, I'll admit I was more than 3 minutes, but I apologize.
If you want additional time, I'll have to have a motion from, and how much additional time are you asking for?
I think you give me 3 minutes. I need more response than I have a
Well,
question.
I'm sorry, that's, if I give you 10 minutes, which you've pretty well close to already, I think I'm not being fair to everybody else.
I would hope you would be fair. I think this is an exploratory matter. You mentioned that's not codified as an ordinance. It's kind of looking at this, and that's the development phase of what these commissioners, yourself included, are trying to do. I would only defer to say that the more input you get from the public, the more questions are raised, the better you can deliberate on the matter. So I appreciate if you can extend me some more time, if not at this time, later.
Well, do I have a motion to extend additional time?
Sorry, how much additional time
said
the
3 minutes.
gentleman needs. He's had more than 3 minutes now.
Okay, we have a motion
Make the motion.
to do what?
Allow him 3 additional
3
minutes.
additional minutes. Do we have a second? Do we have a second?
Second.
We have a second? Okay. Let's have, all those in favor, please say yes.
Yes.
All those opposed, say no.
Oh,
Okay,
Thank you.
thank you, sir. Next card.
Stu Buchanan.
Let's run the time. Particularly with this guy.
Thank you. My name is Stuart Buchanan. My working address is P.O. Box 1545, Titusville, Florida 32781. I promise you I will not take up the 3 minutes.
Yes, sir.
I'm here tonight representing existing business owners that have existing restaurants here in Titusville, Florida. Previously, I've had the pleasure of working for 5 different municipalities in 2 counties on different roles in the planning. One of the last ones being I was a senior planner on the county staff. I was also the county's expert witness and appeared at various what's called DOA hearings, Department of Administrative hearings on behalf of the county. I will not ask you hypothetical situations and ask you to comment on them. I researched this, and as previously stated by staff, I saw that this was generated because of an interest in microbrewery and ordinance related to microbreweries. I believe your staff is absolutely correct. The noise ordinance comes into play when you have a situation like this, CUP or no CUP, the noise ordinance comes into play. You would simply contact code enforcement or part of your police department to address that. I'm going to ask simply 2 simple questions I'm going to direct to the chair, although you may refer them to your planning staff or your in-house legal counsel. I do not believe that this ordinance has a great effect on any existing restaurants, but there are many restaurant owners here tonight that need that reassurance. And so here are my 2 questions. For existing restaurants that already have outside seating, will they be required to go before the city council and apply for a retroactive conditional use permit. I don't see that in this ordinance. I know that many of the existing restaurants, when they have different events, as your staff talked about Harley Davidson, they apply for a special event permit. That's the process that they use. So I'd like to know specifically the restaurant owners, if they could be reassured that they're not going to have to come in, existing restaurant owners that don't change their conditions, that don't expand their seating, that stay within their approved site plan, are going to be required to come in and apply for a conditional use permit as part of this ordinance. The only other thing I'd like to point out to the board is that in section 1CB, it talks about residential property line versus zoning district language. Those are two very different things. So if you have a house that has a commercial future land use and a commercial zoning district and it's grandfathered in, the way this is written now, because it's being changed to say residential use, residential property line instead of residential zoning district, that house will impact that area that's been designated for commercial use. Anyway, that's my two questions that I asked the board, and thank you for allowing me to speak.
Thank you, sir. Staff, would you like to respond?
Sure. So with all great planning answers, the answer is it depends. The site plan, if the site plan for an existing restaurant included an area for outdoor amplified entertainment, then it would be vested. Otherwise, if it did not include that on the site plan, then it would require a CUP.
Thank you. That's what I thought, but the restaurant owners wanted to hear from the staff.
I would concur with the CUP answer, but the other conditions that may exist would require compliance. In this code, if it were changed to apply throughout the city, the other components such as the placement of the outdoor seating is going to come into question. And I think that they would be treated as non-conforming and vested, but it would of course limit the ability to expand.
And we completely understand that. In other words, if it's existing and it's vested, they would have to come in for site plan approval, perhaps trigger a CUP requirement, but existing restaurants are existing restaurants and bars. If I understand your counsel correctly, as long as they're not expanding. And again, most of these venues utilize the special event process for a couple times a year, St. Patrick's Day, New Year's, whatever the case is, when they do end up having outdoor entertainment. Thank you very much for allowing me to speak.
Next card.
Kathy Musselman.
Good evening, commissioners and city staff. My name is Kathy Musselman, and I am the property manager for Titus Landing. And I'm here representing Titusville Harrison 1 and Excel Project Management Company. I appreciate the gentleman's concerns that he addressed with the noise at Harley Davidson. And I just wanted to state that staff is correct, that Harley is, and they do ask for or submit a special events permit, which they receive for all of their events that they conduct on the property, as well as we do for any additional events that we conduct on the property, and other organizations such as the Titusville Kiwanis did a Christmas event on the property, and they too submitted and received special events permit for that. One of the things I would like to note is that I've read the proposed ordinance, and I believe that the current restaurants and the outdoor seatings at Titus Landing all are far from the property lines, so we don't have an issue there. And really, there isn't any noise going on except for maybe a little amplified music coming from salsas. But again, it's far from the property line. And the other point I wanted to make was that we have asked Harley Davidson, and they do comply, to try to redirect the speakers on the bands that are playing so they're not projecting towards any neighborhoods, but projecting back in towards the shopping center. And we also They also shut down their events, probably 8 o'clock is the latest in the evening. I just wanted to bring that to your attention because the gentleman addressed his concerns.
Thank you.
Okay, thank you.
Any questions? Don't see any. Next card.
There were some restaurant owners. Did any of them want to speak? Attached to Mr. Buchanan's. Jason Reckman.
Hi there, my name is Jason Reichman. I live at 3 Indian River Avenue, Unit 306. And I just wanted to say that upon finding this out, which I know it really wasn't advertised yet, that I found out secondhand from another restaurant owner. And I wanted to come in and say that we went through a process about, I don't know, it was 10 years ago or so, where we have to have an after-hours permit as already to open up past 10 o'clock at night. And so you kind of already have the teeth in place for places that do not comply with the noise ordinance or other things that we have to do to make sure that we're doing the right thing after 10 o'clock in the evening. So this seems a little bit silly that we're exploring this because you already have the tools in place for a particular location that doesn't comply. And so it seems like you're doing, it just doesn't seem quite right. I'm not saying this very eloquently, but what I'm saying is there's already an after-hours permit that we have to apply for, and it already gives the city the teeth to go after those places that do not comply with a noise complaint or issue. So just wanted you to realize, if you don't realize, that there's already that in existence.
Okay, thank you, sir.
That's it.
Yes.
I just wanted to elaborate on that. I was going to mention this in my report at the end of the meeting, but at the last city council meeting, there was a request for information from the commission at petitions and requests regarding the alcohol sales in our code. And in response to Brevard County discussing the expansion of alcohol sales, my office has prepared a memo going over the after-hours permit that was just mentioned, as well as what the requirements and restrictions are on alcohol sales in the city of Titusville. And so just for the record, I wanted to let you all know that that's something that's going to be brought up for discussion at the next city council meeting.
Okay, thank you. Next card.
Louis Sanders.
Ready to go?
You're good. Good to go.
Louis Sanders, 3510 Sunset, Scottsmore, Florida, or via the mail system, MIMS now, but I'm still from Scottsmore. So, but I am with my son here and his wife. My wife are owners of Shiloh's Steak and Seafood. And, I came before the commission quite a few times when we were 6 years ago getting our outside seating, because the restaurant had been there for almost 30 years and they never did anything with the outside seating. And it being right on the river like it was, we felt it was really imperative that we added the outdoor seating, and we did, and have been very successful with it and would not make it without that. Titusville has a need for such places and all. I know y'all got a difficult job here trying to figure out which way to lean on all these things, but entertainment, outside seating, sometimes, our young people is the ones I'm trying to stand up for tonight, because I'm in bed long before any of these hours will affect anybody. But the young people, they want to go out and they want to have dinner, a few drinks, listen to music. Titusville has very, very few places you can do that at. Very few. And as we grow, and we are growing, those young people
millennials working at the Space Center and all, if they don't have a place to do it in Titusville, they're going to go to Cocoa Beach. They're going to go to Melbourne. They're going to go to Daytona. They're going to go to Orlando. They're not going to, they're not going to not go out. So I'm just asking that you really seriously think about the impact to the businesses itself. For us to shut down at 10 o'clock, it would be like, why even be there? Because there's a lot more goes on in the next few hours than there were prior to that, with a different crowd of people almost. Us seniors, we go in, we eat 5 o'clock, 6 o'clock, and then that 9, 10 o'clock, 11 o'clock crowd is the younger people. And I don't want to see us do anything that would hinder more businesses wanting to be in Titusville and wanting to entertain our young people reasonably and responsibly. And so in with the staff, the attorneys and all, when you drafting these things up, ask the business owners, ask the public. Thank you for your time.
Thank you. Any next card?
Kyle Sanders?
Kyle Sanders, 3508 Sunset Avenue, Mims, Florida. I own Shiloh Steak and Seafood. So we actually kind of only had one question I just wanted clarified. And in adopting what you were speaking about, changing the zones into being all in Titusville, the shall have outdoor food service and music or other entertainment terminate no later than 10 p.m. on weekdays, Monday through Thursday, and 11 p.m. on weekends, Friday and Saturday. So that now striking that and just saying, residential within 50 feet of a residential, that does impact my location, that it does impact several locations. Is that, are we non-conforming? Do we have to conform with that if that's passed, or since we're existing buildings, will that not apply?
I think that if the city intended to exclude existing businesses, then it would be helpful to add a sentence in this section saying, except for businesses that are previously approved, something to that effect.
That's definitely a clarification that I, would think needed to be put in there because, cutting off an hour of food service to, I have almost 150 seats outside during the week and another hour on the weekend. There's a lot of times we do special events. I had the extended hours permit. We do events till midnight. So that's an entire hour that, astronaut high school reunions, we host, probably 10 of those a year, Titusville reunions, and they a lot of times stay past 11. So I'm going to have to shut that deck down and send everybody out. That's going to impact my business greatly. So I just want some reassurances and, maybe this needs to be tabled and, like Mr. Richards said, really clarify some of these things. It's got all of us current restaurant owners, nervous right now because we've just suffered a pandemic. I mean, we were, small business all over the United States were affected. Restaurants, bars, arguably were affected the most out of all those small businesses. And so right now, and also the state of Florida has just passed a minimum wage increase, so now we're having to figure out how are we going to adjust and conform to that. And so now we've got an issue like, instead of thinking about being able to expand hours to increase business, now we're looking at, well, we maybe have hours taken away from us. So that's a big issue. We just want that. We want that clarified and need some reassurances that's not going to be an issue. Thank you.
Mr. Sanders, about how many feet are the speakers from the residences, the condos?
Well, that's
to the north.
The speakers are, they're probably, 150 feet or so, but, is it it doesn't say the actual amplified speaker to the property line, to the residents. I mean, the wordage is just not very clear. So that's kind of, that's where our concerns are.
Thank you.
I have a question.
Another question, sir? Yes.
Because you're on the water, sound is totally different.
Absolutely.
And so this ordinance as it stands is not clear on the fact that it's your business that produces music
Mhm.
at a certain hour
Mhm.
is also on the water. This ordinance does not state any variables on that, does it?
No.
So you wouldn't be in compliance anyway because of that condition.
Well, I mean, I'm not sure what you're saying. I mean, we're not actually emitting sound on the water. I mean, we're probably
You are
set
on
back.
the water and sound is being emitted by you, by your musical entertainment,
Right,
and you're on the water.
right.
Unless you do without
I'm not sure
music.
what the water has to do with.
The water has a tremendous,
Yeah, but I mean, you don't have the language in there, so I don't see why that.
that's exactly what I'm asking. Our language does not stipulate that, does it?
Right, no.
Thank you.
Another question?
How long are you guys open on your special events? Is it past midnight or at midnight you close down?
Oh, a lot of times we'll add 1 extra hour and stay till midnight. We never, I mean, we have the extended hours used till 2, but we'd never utilize.
So is that 11 or 12?
The extended, special events, 12. Our normal business hours are till 11. Thank you.
Chairman, if I can just add some extra information
go
about
ahead.
the extended hours permit. So the extended hours permit allows sales until 2 a.m. on Monday through Saturday and until midnight on Sunday. And with that process, business owner has basically 3 strikes. If you're called on code enforcement 3 times, you lose that extended hours permit. And so it's a way of addressing any repeat nuisances that are coming from the same business that aren't addressing the sensitivity to their surrounding neighbors.
Well, as a point of clarification, don't you think it would be a good idea to place in this ordinance a provision grandfathering those in that is, or clearly states that this provision ordinance does not apply to those individuals that have special hours, extended hours permit?
Personally, I don't see the distinction in that being a nuisance of being produced by older businesses or existing businesses versus new businesses. I think the nuisance happening at a specific time is the same to a adjacent residential property, whether it's an existing business or not. And so I would say my personal preference, if you're asking me, is to rely on the extended hours permit process, whereby if a business is being a repeat offender, they lose that ability to stay open past when the other businesses are allowed to stay open.
If I could elaborate on that, I think that part of what we see, what Eddie, the planning staff has identified with this proposed change is that it prevents any new businesses from coming in and establishing any sort of outdoor seating unless they can meet the standards that were set for the DMU. The staff prepared a map of the DMU. It's in your agenda star folder on your laptops if you want to see where this ordinance currently applies. It's only for the downtown mixed use, and that map is available for you to see what small section of the city that is. By opening this up to the entire city, that's creating these rules for any outdoor area of seating for any new business would be have reduced capability to open up. And I think that's why, Eddie, correct me if I'm wrong, staff has difficulty recommending approval of an ordinance that's drafted before you tonight.
Okay. Any other questions? And Member Rice? Go ahead.
Okay. Would you repeat that last sentence you made?
I don't think that staff recommends approval of the ordinance that's presented. That
Okay.
this ordinance was presented for discussion to talk about the zoning districts that would be impacted, to talk about the nonconformities that would be addressed, to talk about noise impacts, all the things that have already been discussed. We wanted to invite the community to weigh in and have a better discussion before this ordinance is advertised for a public hearing.
But it was not advertised to the community to be here tonight.
Yes, they were individually invited by the planning director. She sent.
So I see a lot of nods, not yeses, no, in the audience.
Okay, Member Rice.
I just need to get something straight in my head with, I read the noise ordinance in preparation for this meeting. I read the ordinances that are in front of us tonight. I did not read the outdoor, or not the outdoor, the extended hours permit. I just want to get something straight. Is the extended hour permit, is it about outdoor seating or is it just about extended hours?
It's specific to extended hours for alcohol sales.
But it has nothing to do with outdoor seating. It's whether it's inside or outside, the extended hours permit is because of alcohol sales.
Correct.
It has nothing to do with indoor or outdoor seating. Is that a correct statement?
Correct.
Okay. Thank you.
Next card.
Audrey Hunter,
She passes.
Laura Lee Thompson,
Laura Lee Thompson, 3550 Irwin Avenue, Mims, and I'm a co-owner of Dixie Crossroads Seafood Restaurant. And I too heard about this ordinance from another restaurant owner. I think the notice was sent to the restaurant, but I'm not there that much anymore, and I had no clue this was going on. I agree with everything Lewis said. I would hate to see the city pass something that's going to have the possibility of limiting new businesses coming into town. We're trying to attract younger people to Titusville, and as Lewis said, there's not a lot for them to do late at night here in town. And as far as I'm concerned, I don't have outside dining and I don't have outside entertainment, but I might want to at some point in time. So grandfathering in the restaurants that have those existing conditions now, it's not going to help me. During the COVID, outdoor dining saved a lot of restaurants. And so we don't know what's going to happen in the future. So limiting under these circumstances, it could really hurt businesses in the future, and it could hurt our ability to attract some new restaurants that younger people are going to like into town. Like Lewis, I'm in bed by 10 o'clock, but I know that younger people, I mean, I was young one time, and I didn't shut down until 2 or 3 in the morning. So I think limiting restaurants that have the outdoor dining and the outdoor music, having them close at 11 o'clock on weekends seems really excessive. I think midnight would be better. And Woody, you brought up a really good point. So you have an extended hours permit that allows you to sell alcohol, but you have an ordinance that says you got to shut your outdoor deck at 10 o'clock or 11 o'clock. So does that mean you got to make everybody get up from their tables on the deck and go move inside if they're going to continue drinking until the extended permit hours go into effect? So I think there's a lot of places where there's vagueness that needs to be clarified in this ordinance. And I look forward to the next round. Thank you.
Thank you. Next card.
that was the last card.
Last card. Okay. Commission, now we return this back to the commission for your comments, input. Again, Member Riley.
I'd like to speak up for the people of Titusville who are trying to stay safe in this pandemic that is still ongoing. And I have two daughters, actually three daughters, that live either in Brooklyn or San Francisco. And those communities are certainly different from Titusville. They're much more dense than our city. But one thing they all do is they have all of the businesses there that are restaurants have put seats outside, even when they're using all of the sidewalk in front of the restaurants. And that practice has been a godsend to the people of those cities in being able to go out in a safe fashion and patronize those businesses. And I would hate to see any kind of ordinance written that causes outdoor seating to be retracted or possibly penalizes a new business that may go in for a lot of outdoor seating. So I think we ought to be at the forefront of this, and we ought to be emphasizing that we are in favor of outdoor seating. Now, certainly there are some issues probably with the noise ordinance, but I don't think it should be paired with the outdoor seating, which is such a good thing, and I wish it was practiced by everyone that has a restaurant in Titusville.
Okay, thank you, Member Riley. Any other comments, questions by, yes, Member Spardale?
I am continuing to be concerned about the mention of enforcement. I would like my police department to be enforcing something other than noise, especially in an evening paired with entertainment. I think that the 3 citation is maybe reasonable. On the other hand, I'd like to know from staff exactly if a resident complains about noise at the time, who comes and investigates that?
Assuming that that's after, like, evening, after,
Yes.
then the department would, in lieu of code enforcement.
Okay, so the police department comes off the road from wherever they are to go to Shiloh's to see if the guitar playing is a little bit loud on the amplifier?
I believe that's correct.
Okay, and if they come 3 times, then Shiloh's has no more chance of a special permit?
Correct.
It gets revoked for a year, I believe. I'm pulling up the ordinance. The only time a after-hours permit would get revoked is after a public hearing in front of city council. It's not automatic after those citations.
Okay.
All right, any other questions or comments by the commission? Member Rice?
This does have a lot of conflicts with the noise ordinance. I read the noise ordinance, and what I read here, correlation's not our conditional use for special permit use. And the way I departmentalize that this ordinance here is all about outdoor seating, not about noise, about outdoor seating. So there are problems though with what I heard tonight with noise, okay, that we need to address. But that should be in the noise ordinance. This is outdoor seating. They should be done at the same time, so they correspond and allow businesses to do what they have already done in certain places out. And I think we do need to be sensitive to the changing world when it comes to outdoor seating, because I personally have, to this day, have not eaten inside a restaurant. I've sat outside every restaurant that I go. I take care of an 85-year-old mother, and I can't expose myself to something and bring it home. So now I take her and we sit in the car and eat. So I think it's a new way of doing business. And it's a way that we need to get used to. I think drive-throughs are the other thing that's going to be pretty important to restaurants in the future also because of this. But the one thing, and I decided to do a little research on sound. And I am an engineer, but this is not my field of expertise by any means, okay? But in all my research, what I have found is that for every doubling of distance from an object that makes sound, the sound level drops 6 dB, okay? So, for instance, if I have normal voice, that 1 foot away from you, a normal voice is about 70 dB, okay? At 2 feet, that becomes 64, okay? And if you go on out by 10 feet out, it's only 53 dB. By 50 feet, it's 35. So it's not a linear relationship, but there is a relationship with distance. And I think what's important for the board to understand that, let's use 50 feet, because this is what that ordinance says. For me to get 6 additional dB, that's it, the next distance is 100 feet. So the order of magnitude changes drastically between 50 and 100 because it's doubling of the distance for every 6 dB. Okay. And I've pulled, in my research, I pulled that from 3 or 4 different sources, confirmed that this was sort of a standard. It's simplified because there's so many things in acoustic sound, you know, the media, the weather, the humidity, on the water, not on the water, all those play factors. But this was just one standard that stuck out as a uniform sort of approach of sound level travel. Okay? So that's something we need to consider. A normal voice is 70 at 1 foot. A raised voice is 76. A very loud voice is 82. Someone shouting is 88 dB. Okay? A baby crying is 110 dB. A rock concert's 120. A telephone ringing, I think old-fashioned telephone, always what they meant, but it's 80 dB. And a noisy restaurant is 85. And that's at 1 foot from the source. So I made a little chart of all these and charted it out of where they break down and where do they fall with our noise ordinance that says 60, 50, you know, they're depending on where you're at, whether it's residential, it's 55, and then it drops to 50. If you're commercial, it drops to 60. And if you're industrial, it's 65. And what the noise ordinance also says is that if you're commercial and you abut residential, okay, then you must meet the residential dB at the property line. So there is a distance there. So if we limit something to 50 feet, and go back, if the instrument on stage makes X, 50 feet away, it's going to, sound travels at Y. It's going to be a dB of Y. So I thought that was interesting to say that. In this outdoor seating, you're talking about conditional use for amplified music. There again, see, I have a tendency to take that stuff out and just say, you know, this is all about outdoor seating, and the other is the ordinance for noise. But yet, it's conditional use here, but under the noise ordinance, it's a special permit. And what the special permit does not say, it doesn't say, it says that you can only have an event that can't last any more than 15 days. But it doesn't say how many days. I didn't see anything here to say how many days I can have a special permit. So I can come in and get a special permit 15 days, and at 16 days get another special permit. It doesn't exclude that. So, and what's the difference between doing a special permit for noise and then this conditional use permit? Okay, A special permit is approved by the city manager with certain criteria. I see no criteria in the conditional use permit. So, you know, to me, there were some differences there. You know that under special permits, though, here's a statement that taken Harley Davidson, okay, under special permits. And this confuses me a little bit because this is under special permits and section F, okay, which is the special permit section, item number 4. I read this. It says, no permit shall be issued to allow the use of loudspeakers or sound amplified devices on the exterior of any building which at any time exceeds the sound level limits in table 1. Can't do it if you're exceeding those sound tables. So that limits it. There again, it's about distance. So I thought that was interesting. And then it goes on to prohibited noises. And it talks about radios, musical instruments, and phonographs are prohibited. Okay. Music, isn't it? Yelling's prohibited. So I think there's some work here to do to marriage outdoor seating as standalone and have a noise ordinance that allows businesses to operate. And I think the marriage, they almost have to go hand in hand together, but I think they should be separated. One should be outdoor seating and the other one should be noise ordinance. See the other comment? The only other thing, the outdoor seating, that item on page 12 of our agenda, I don't disagree with it, and it's existing, or I guess this is all new. It says, shall maintain either a 5-foot wide clear pedestrian path or 50% of a sidewalk width, whichever is greater. I agree with the 5 feet because there's ADA requirements. You have to meet them. But what I don't agree with is the 50% rule. And the reason why I don't agree with that is if I had a 20-foot area in the front of my business, like we might have in some areas downtown or in Titus Landings, okay, it's 20 foot. Now I have to preserve 10 feet of that by this ordinance because it says whatever is greater. Okay, so now I'm taking 5 feet and I've already capitalized it and made it 10. When really all it's probably is necessary for ADA and pedestrian traffic to get by is the 5 feet. But why limit to saying, you know, because I have 20 feet now, I have to preserve 10 and keep it open. I can't have any tables or anything there. That seemed odd to me. Okay, that's not very business friendly either. That was item I. I think that's the bulk of what I saw here. I do believe that, you know, this ordinance, noise ordinance, if we'd like to make, I think we should. And the outdoor seating is not ready for prime time. That we need to do a little bit more work between those two, but one, they should stand alone. That's it.
Thank you, Mr. Rice. Anyone else have any comments, questions? A couple of comments. I did look at the zoning map up and down US 1, up and down Garden Street and State Road 50. There are countless areas in which community commercial directly abuts up against single-family residential. So I think we have to keep that in mind. Our review of any ordinance. One question I have as far as outdoor seating in the rear yard area, setback area, outdoor seating allowed in that area. let's say like community commercial, there's a 25-foot building setback. And I build a deck and have outdoor seating within that 25-foot area. And part of the reason why I'm asking this question is because for years, there was a code enforcement matter in 2 different locations in Titusville where there were significant problems. There wasn't music playing. It was simply alcohol served. Here, individuals very cheerfully interacting, and the neighbor, this is on Harrison Street, directly behind it, couldn't sleep at night. There was major problems. And so my question is, if there's a 25-foot setback, is this, can they build a deck and have the outdoor seating directly adjacent within 5 feet, let's say, because lots of accessory uses are allowed in 5 feet, up to 5 feet, is that allowed? Because this is not clear at all to me.
So I'll just remind the commission again that the criteria, and I'm looking at page 12 of 47, the criteria that's on this page is the language that already exists for the downtown for outdoor seating. And the intent with this ordinance was to strike specifics of making it downtown DMV related, apply it across the city. So there may be some instances where that doesn't make sense for restaurants or businesses outside of the DMU. Subsection F, blue F or red E, depending on which your color preference is, says shall be restricted to the sidewalk or building frontage of the subject licensed restaurant, the rear yard or a side yard if the side yard is abutted by a non-residential use or zone, unless otherwise specified in a binding development. So that's specific to the front of the building as opposed to sides or rear, unless it's part of a binding development plan.
Okay. I tend to, number one, I desire to review this. Number one, I agree that outdoor seating is important. We should encourage it rather than discourage. And number two, I don't think there's any desire to impair or impede the current operation of any of the businesses, restaurants in Titusville. I think what we saw is a few isolated areas the code addressed outdoor seating. There were numerous other zoning districts that didn't even address the issue whatsoever. And it should address it one way or the other, giving some guidance as such. So I think that was one of the reasons. I do tend to agree with Mr. Rice some that, I mean, it looks like paragraph A and B are dealing primarily with music, amplified entertainment, amplified music, whereas all the other provisions just deal with seating. And perhaps the city staff should really look at whether you can separate these out and address amplified music differently, because you may want to have better or more larger setback or protections where there is amplified music, because it, like I say, there's countless areas. If some of these properties that are CC are directly adjacent to a single family residential, the city needs to have or addressing that up front rather than having a problem then addressing it later. So that's my comments at this stage. Anyone else have any comments or recommendations? Bryce.
I just have another question, staff. Do we know how many binding development plans or how many site plans have been approved with outdoor seating and for our restaurants that are existing? Do we have that information?
No, we don't.
Okay. And I know the retention period of site plans, 7 years, I believe. I could be wrong on that because I'm just going by memory. I know we have a tendency to keep records a lot longer in Titusville, which is a great thing. But how does a business that has been established, for 30 years prove that they have an approved site plan or with outdoor seating? How do they prove that to you?
So I would say if any business is curious, they could ask for a public records request for their site plan, and we could go through the archives to find it. Otherwise, we don't have those files are not on a digital database, kind of like the county has their building permits online. So really the public.
Probably some even on microfiche,
Right.
Back then. But I guess my point is that if I've had it for X amount of years and we can't find the records, okay, is it approved or not approved? Is it existing or is it not existing in the eyes of the city? Which one is it?
I can't answer that.
Any other member of the member Richardson? Yes, sir.
I'm prepared to make a motion. Are we through with the discussion?
Sure, let's go ahead and see if you get a second.
I would make a motion that we table this item until such time as it addresses the outdoor seating issue adequately, and that we have a workshop session when staff is prepared with the proposed ordinance to allow all the businesses that are involved to participate in a workshop session.
Is that your motion?
Yes, staff, do you need a timeline? How many months or weeks or?
Well, real quick, Chairman, I would say first off, based on the discussion tonight, I haven't heard many issues with outdoor seating specifically. It sounds like most of the issues have been with the noise and the noise ordinance. So if we're gonna follow the suggestion of splitting them out, I think it'd be helpful to know, are there issues still with outdoor seating that need to be addressed in this ordinance, or basically some more direction on what you want to see in all three of these ordinances. So now we've got outdoor seating, got the noise ordinance, and we've got brew pubs, I think, may still be on the table for discussion. So if you want to see all three of those handled at the same time, as far as outdoor seating, I haven't heard much, so I would need some elaboration on that.
I think the only thing with outdoor seating is the distance between the business involved and the single family or multifamily residential area. 50 is probably not adequate enough. 100 probably is, or West Melbourne is 135 feet. That needs to be addressed. That's the only thing involving the outdoor seating that I see as an issue. Take out the music and everything else, the noise.
Good. So that was just feedback, Commissioner Richardson. Or did you make a motion? All right, do we have want to restate it, the record?
That staff come back when the issues are addressed adequately involving outdoors areas of seating and the other things regarding the noise ordinance and the brewery ordinance at a time 2 months from now? Does that satisfy the staff? That it be advertised adequately so everybody knows about it?
So I think if you're asking for just a change to the setback in outdoor seating, that's something that we could turn around to you for the next meeting. It wouldn't necessarily take 2 months. But the sound ordinance, similarly, if we can articulate tonight what changes you'd like to see specific to the sound ordinance, we could probably draft that for you and have it to you at the next meeting. I don't know that we would do 2 full months.
I was just asking you.
Okay, any other comments about,
Are we separating outdoor seating from entertainment?
Yes.
Just to be clear, that's outdoor seating from noise ordinance, correct?
If it's
and
separated,
as far as amplified music, is that going to be addressed separately?
what he said, yeah.
So my understanding is that you would like to see that addressed in the noise ordinance.
Yes. I would.
Okay, is that the general consensus?
Okay, appears to be. Okay. So we have a motion, we have a second by
I'll
Member
have a
Speidel.
second if they're separated, yes, sir.
Okay. Any further discussion, Mr. Rice?
Yeah. Setback. Talking about amplified music, just setback for outdoor seating. Some scenario that the chairman brought up, deck and residential behind. If I just look at loud voices or shouting voices, okay, at the source, it's 88 dB. 25 feet away, okay, that's 59. Okay. Not quite the standard that abuts residential after 10. That's standard.
At 100.
It's actually 55 during the day and 50 at night. But at 50 feet, it's 53. So you're 25 to 50. At 100 feet, you're only getting to 47. But it's a whole nother 50 feet. But it's the economy of scale here, what's at play with doubling the distance to get to where we need ordinance. Okay? 100 feet is going to kill a lot of sites. 100 feet's a pretty far distance, and I can appreciate that. I mean, if I live behind it, I can appreciate it, but I live downtown. I hear street parties all the time. That's great. I live downtown. That's what I would expect from downtown. I chose to live. You know, but so I think we have to be very careful that the outdoor seating and where the distance is related to noise. So I don't know that, I think they do have to be separated from an ordinance standpoint, but from a decision standpoint, they can't be separated. They have to go hand. So we make good decisions.
Any further discussion on the motion? Roll call.
What?
Yes, sir.
I just want to get clarification. The motion included looking at noise?
Yes.
Okay.
Yes, it did. Roll call.
Member Riley? Secretary Richardson?
Yes.
Member Porter?
Yes.
Member Grant?
Yes.
Member Rice?
Yes.
Vice Chairman Speidel?
Yes.
Chairman Severs?
Yes. All right, the next item on the agenda is Brewery Ordinance. Staff?
So this item begins on page 14 of the agenda. That's a second. So of course, this is following the January 20th, 2021 meeting in regards to the proposed ordinance relating to brew pubs. Staff was requested to respond to some of the concerns that were made in regards to definitions for barrels, liters, and gallons, as well as the distances between brew pubs and residential. All right. So currently, as it stands right now, the code defines craft brewery as a small brewery in which less than 25% of the brewery is owned or controlled by an alcoholic beverage industry member. They may have a tasting room, the production and sale of beer and wine without a limit and permitted in the regional commercial, industrial, RMU 500, and urban mixed-use zoning districts as a limited use. So here in the state of Florida, we have two different licenses for breweries. The first one, the CMPB, it limits the manufacturing of malt beverages to 5,000 barrels per year and allows on-site consumption only. Second, the CMPB has no production limit and allows brewing, distribution, bottling, and tasting room on premises. I also want to point out the size for the barrels. One barrel equates to 31 gallons, which is 248 pints. So for the proposed ordinance, this would continue the allowance of the tasting rooms. Obviously, the production and sale of beer and wine, the limit of 15,000 barrel a year, and continue in the RC, the industrial RMU 500 districts. Also with the proposed ordinance, it would be expanded as limited use to the tourist, the community commercial, DMU, SMU, RMU 400, and urban village districts. In the urban mixed use, we'd see a change from a limited use to CUP, and there'd be a 15,000 barrel per year cap on the production amount. CUP set even more stringent limits on production based on the surrounding uses. That concludes my presentation. If you have any questions.
Any questions of staff? Richardson, do you have a question?
Well, I wasn't going to press my button. I meant to turn it off, but yes, I
Okay.
have a question.
Yes, sir.
The last two items strike me as being strange. Established a 15,000 barrel a year production. And why should the conditional use permit set more restricted production limits? Why should it?
Why should it set more based on the surrounding land uses? So as far as, are you asking what exactly?
I think I can answer. So the CUP doesn't necessarily have to restrict it, but if for that particular site, city council felt that there were, and P&Z if you wanted to recommend that to city council, that for this particular site, let's say it's completely surrounded by single family residences and you want to make sure that it doesn't become a large scale brewery like Anheuser-Busch next to some single family residences, you could then further restrict those barrels down if you needed. It's not saying that you have to though.
Member Rice, do you have a question for Grant?
I think the reason is because there was discussion about lowering the number at the last meeting. And so the staff recommended 15,000, but if there was a reason for a specific location to not go that high in terms of production volume, then the CUP would be the tool to limit that production capability based on this commission's discussion of maybe having less than 15,000 as the limit.
I'm struggling with it because one, this is done indoors. Microbrewery, okay? And what impact does it have on the surrounding area? And why would we limit it? There's no criteria what we're using as reason why is just because I don't want you to produce 15,000 barrels? Is that the criteria? I mean, what if I don't like selling 15,000 widgets in a store? Can I go and, I mean, I don't see the correlation. Why you're picking to limit something that unless you guys have a scenario or something has been brought up that I'm not aware of that warrants a limitation. That's what I'm trying to do. What warrants a limitation? Really what it boils.
But generally speaking, the conditional use process is used to mitigate nuisance. And I understand what you're saying is production limit and the nuisance needs to be a nexus those two. The CUP doesn't necessarily have to only focus on limitations on the production, the amount of production. It could focus on other factors like a buffer or something else if the commission or the council felt that there was a need to mitigate an additional nuisance. We just gave that as an example since it was part of the discussion, like Chelsea mentioned.
Well, okay, maybe I'm not explaining it very well. Okay. I came in to do a microbrewery, and right now I can come in here and do that for 15,000 barrels with no conditional use. What's going to trip the conditional use? What trips it? Because there's nothing here. I have a right to come in and get 15,000 barrels. Who's going to make the decision? Well, no, you can't do that. This one is going to be the conditional use one. When this guy over here came in and got it, and he was allowed 15,000 barrels. Why are you treating me different than what the last guy you permitted? That's where I'm struggling.
I understand. I can't find the section right now. If someone else can find the uses where it requires a CUP.
The use table's on page 27. I've just located it.
Thank you. I was struggling there for a little bit.
And it's under UMU that's proposed for conditional.
Right. And the reason why that is for UMU is because currently the code limits alcohol sale establishments in UMU based on a 2009, I believe it's 2009. I've got it right here.
It's the language in C2 on the bottom of page 27. Woody?
So you're saying the only one that has to come in and get conditional use is something that's in the UMU category. Everyone else is allowed to do the 15,000.
Yeah, zoning based.
Okay, that explains it. Now I get it.
It's just, it probably could be written better on this page somehow, but that's what the intent of the code as drafted says.
Now I see why you're picking out a specific zoning category, saying only in this one. Okay, I get that. All right, my next question then would be, in the old version that we got in February, I think it was 3rd, a lot of these had P's, not L's. And they were permitted, and now they're limitations. What changed? Why the difference between those two?
The permitted with limitations would assign the maximum capacity at 15,000 barrels. So that's the, instead of relying on a definition, which may change, like if we were to use the state's definition, if the statute says it's 15,000 barrels and that were to change tomorrow, by providing it here in the code, 15,000 barrels, that's the limitation. If you go above that, then it's not permitted.
Member Grant, are brew pubs allowed in residential areas?
Currently, urban mixed use may have residential, and then the industrial districts which don't have residential but may have a residential component for a security guard, so not really. This would expand that to limited use in tourist, which could have residential, SMU, and the DMU, as well as the Army
and
400.
UV.
And UV.
UV was my concern initially. I had a concern about brew pubs being in residential areas, and if I remember correctly, residential is allowed in urban village.
Correct.
I see it has limitations, but I'm not quite sure what those limitations are.
Again, those limitations are on the bottom of 27. The
Yes.
standards for the limitations, it's just the 15,000 capacity as the limitation. That's it.
That's it.
That's it. And so as Eddie said, that to enforce that limitation rather than relying on the definition, they put it in the limitation section of the code.
But this is just personal, come from me. I have an issue with them being in residential areas, that's all. I have nothing against brew pubs. I have nothing against them, except I do not think they should be in residential areas or in districts that are zoned residential.
So 2 points on that. To reiterate what was mentioned during the last time that this was discussed, Member Murray at the time mentioned a couple of examples like Salsa's restaurant that's in the urban village, and that they sell alcohol in a district that could have residential. And then the downtown mixed use area, the Playa Linda Brewery, is another example where there's residential nearby. So just to give you some examples, reiterate what was mentioned at the last meeting.
Feel a problem coming, that's all. Thank you.
Couple of questions I have. I see on page 14 the licensing. There's one license that's 5,000 barrels, as I see it, and then there's unlimited. Why doesn't our ordinance track the state licensing division? Why are we choosing 15,000 barrels?
So 15,000 barrels is a standard that's established by the Guild of Microbreweries, and they essentially establish a microbrewery is anything from 0 to 15,000 barrels, and then anything above that is considered a regional brew house. And so it's a standard within their professional agency, professional organization, to establish the 15,000 barrel limit. In the state's requirement for 5,000 barrels, that's only for a brew pub that allows on-site consumption only. And so if you wanted to do any type of growler, like a takeaway container, or if that brewery wanted to expand to where they could sell their beer to a restaurant down the street, you could not do that under the license that only allows a 5,000 barrels.
Okay, thank you. Another issue I raised last time under SMU, section 28-117, drinking establishments, bars, taverns, lounges are not permitted SMU. Why are we permitting an alcohol establishment as a brew pub in SMU?
Yes, sir. I did take a look at that. That is one use that is specifically called out, drinking establishments, but also in the permitted in the SMU are a couple other uses that may have drinking establishments associated with them, like a hotel, for example, or a restaurant. A lot of times brew pubs operate much more like a restaurant that also sells alcohol. We have a number of examples of those, like a Chili's. Obviously, we don't have one here in town, but a lot of times brew pubs act as a restaurant, and so those are uses that sell alcohol that are permitted within the SMU district. There's also hotels, which may have a bar in their lobby, and so that's another example of where a drinking establishment would be permitted within the SMU.
It just seems to me then section 28-117 of the code needs to be clarified, because you're saying something different than that section of the code.
What section is that again?
Section 28-117. I mean, clearly does not permit bars, taverns, lounges in SMU.
I did also look at the district's purpose statement. So that's in section 28.326, and it says here Purpose of the Shoreline Mixed Use District. Based upon historical and existing land use commitments, it is the intent of the district to encourage and enhance a mix of residential, public, semi-public, tourist use, commercial use, public and private recreational uses, wet docks and boat shops. So that's not specific to drinking establishments like you mentioned, but it is showing that the district is intended to be a mixed.
All I'm saying, you should clarify it so there's no confusion, because you have one section of the code you're saying says one thing, and this one says something entirely different. And there should be some consistency between the code sections as such. Anyone else? Member Spardell?
I need clarification on hours of operation. Goes with the chart that you put in table 103-60. Was that
Excuse me, real quick. Do you have a page number?
page number 60?
Thank you.
Is the proposal to close at 10?
So this is an example from the city of
Or
Denver.
just an example?
Yeah, it's just an example.
Okay. So is there a proposal time on the new ordinance, new proposed ordinance? One of the things that was asked for in January was hours.
Yes, it was consistency in hours in January.
Is that what it says?
It was supposed to be.
So, and I think that goes back to where we've kind of diverged with the different discussions. We've got outdoor seating, drinking, alcohol, and brew pubs. So I don't know if you've already addressed hours through outdoor seating and noise, if you would also need an you would also need a time constraint on brew pubs specifically.
Well, I heard an awful lot of a very good argument from restaurants tonight that hours need to be for the senior
if I may.
citizen.
There are
need to be a variety of hours that encourage business.
There is a code section 4-4 that describes the hours for sale for the consumption and service of alcohol. And I believe that it would be appropriate to keep that section separate from the brewpub ordinance. And this section would apply to brewpub restaurateurs and the like.
So it would just be the same.
So the existing code says Monday through Saturday, alcohol can be sold beginning at 7 a.m. and ending at 11 p.m. Sunday beginning at 1 p.m. and ending at 11 p.m. And permits are required to remain open past 11 p.m. And the suspension of permits was what the after-hours permit described. And you heard Shiloh's representatives talking about their ending hours, usually around midnight, but there is an after-hours permit that's required to remain open past 11 p.m. And it is a free permit, but if you violate the code, then it can be revoked.
But do they have to apply for that? 11 still seems awfully early.
The code requires, the code prevents selling alcohol after 11 p.m. unless you have the permit.
Okay.
You have to come in and apply for the permit, and you have to meet the business licensing standards, I'm sure, to get that permit. And then it extends your permit to 2 p.m. or 2 a.m. on a weekday or Saturday and until midnight on Sunday.
Okay, thank you.
So that's what the code says, and if you have any further questions on that, I'd be happy to answer. But as I said earlier, this is a topic that's coming up before City Council on Tuesday for their discussion on whether or not they should amend the hours that alcohol can be sold in the city of Titusville.
We have not opened the public hearing at this stage. Do we have any cards on this item?
No, sir.
No cards? Okay, we'll close the public hearing then. Member Richardson.
And Chelsea, the county ordinance now, is it 24 hours?
I don't know that it's been adopted yet, but that's what was proposed, is to remove the restriction on time for selling alcohol completely.
At the commission meeting Tuesday, they could not reach a consensus, so it was tabled.
I don't doubt it.
All right, any other further discussion? Do we have a motion? I'm not sure we necessarily need a motion unless you want one. You've heard the discussion. Member Rice, like on for a second. I mean, we've had a lot of discussion, and this is not where we're making a recommendation to the city council. I think a lot of people have provided their input, and it's back up to staff to see how they want to revise it if they want to.
Just a general comment. I think we've seen the complexity of these proposed ordinances. And maybe staff should simplify them to a degree. Only thing they're doing as written are keeping attorneys employed. Before at least 3 attorneys.
That's a good thing, sir.
I disagree.
Okay. All right, anyone want to make a motion or any action by the commission? Going once. Rice.
I'm going to ask staff a question. What direction did you hear tonight? I don't know that what I heard then.
With regards to brew pubs,
Yes.
I heard that we need to clarify 28-117 in regards to SMU, that we need to keep it simple, and that we need to, if there's any mentions of outdoor seating or noise, that they need to be separated as 3 different ordinances.
Thing was 28-117, I think it was clarification, which has nothing to do with this section of the ordinance, correct? That's something that you would do that needs to be clarified anyways.
Correct.
Okay. Then I'll make a motion to approve this ordinance as written.
So your motion is to recommend staff continue with refining and in the format that they have presented. Is that correct?
That is correct. I think.
Right. Do we have a second? Do we have a second? We have a second.
Guarantee staff will.
Member Spidell?
We've had several situations where we've asked staff to do that, and when it got to council, that's not what was done. So solemnly raise your right hand.
Well, let me clarify. So,
Well, this is all going to come back to us anyway.
let me clarify. So what's happening tonight is not a decision for a recommendation that's going to go to council. Tonight's been very helpful for discussion purposes. And so we'll make those changes, specifically breaking out the 3 ordinances for further discussion. And with brew pub specifically, there wasn't much direction, so it sounds like you're generally satisfied with the direction that brew pubs is going in. Unless I heard, if you have other input you want to give us, please do so now. Otherwise, you'll see basically the same ordinance next time we bring back the noise and outdoor seating ordinance.
Thank you.
As I understand it, we questioned the difference in hours, right? Okay. Okay.
Yeah.
Your
micro-
clarification
I
is
was-
how all liquor sales.
The section 4-4 of the code applies to alcohol sales throughout the city. Yes.
Correct.
I second Mr. Rice's motion.
Okay. Any further discussion? Roll call.
Member Grant?
Yes.
Member Riley? Secretary Richardson?
Yes.
Vice Chairman Spidel? Yes. Member Rice?
Yes.
Member Porter?
Yes.
Chairman Severs?
Yes. Okay, that's action on the new business items, and next is petition requests from the public. Do we have any petitions or requests from the public? Yes, sir?
Yes, I have 2 cards.
Come on up.
Stan Johnson, 860 Poinsett Avenue. And I'm speaking to you tonight as a professional engineer. I've been employed for over 17 years by the city and the county as a professional engineer. So I'm especially want to make a point to you. I might need another minute, but the point is that I want to thank you, first of all, for what you're doing for trying to protect the trees. But I want to make a point that I think that you're missing a big point. That's what I want to try to make to you, is that I appreciate your diligence, but I want you to consider, and I haven't talked to Mr. Rice and I haven't talked to the staff about what happened with Park Preserve. Park Preserve looks like it's, to me, an engineer, it appears to me as there was a good bit of trees removed because of the 100-year flood zone. And maybe you'll confirm that. But this particular flood zone is with a certain elevation, and this elevation is there's no calculations to back it up. The city does not have the information on how it was prepared, and it's an erroneous flood zone. So first of all, I'm saying is that I believe that, if you have a high flood zone, it's higher than what you're going to do is you have to fill and you have to remove the trees. This is not the case in all situations with trees, because there's been trees removed from that shouldn't have been removed from high ground. So what I'm saying to you is there's something I've written to you numerous times, is that there's watersheds in the city of Titusville that with over 9 square miles of watershed has erroneous flood zones, and I can sign and seal that. And I can't find anybody that's going to oppose that, any professional engineer going to oppose that. And what it does is not only does it have your erroneous flood zones, but what it does, it shows that there's errors in your comp plan. There's errors in your development plans, errors in construction, errors in the finished floor elevations, and that they're incorrect. In this city right now, I can't get any council members, city manager to talk with me about this. So we're stuck. And so what I'm asking you is to consider these erroneous flood zones, because it's messing up your comp plan and all these other things. And I can prove, I don't know, and I can sign and seal in writing is there's flood zones that are wrong. In fact, the city of Titusville had one case in where they accepted 100-year calculations for an area for flood zone that was 3 foot lower than that was which was published on the map. So I'm here. Can I get 30 more seconds?
Do you have a motion? Allow 30 more seconds?
Move we give Mr. Johnson an extra minute.
I'll just
All
say
right, we have
30
a
seconds.
second.
Oops, sorry.
Second. Roll call.
Secretary Richardson?
Yes.
Member Porter?
Yes.
Member Rice?
Yes.
Member Riley? Vice Chairman Spidel? Member Grant?
Yes.
Chairman Severs?
Yes. Go ahead, sir.
Okay, thank you. So what I'm asking you to do is for the city. The city council won't do this. For it to get a professional engineer to review this, to review it in writing, signing, and sealing. What I just told you, which I can sign and seal, and I'm saying you can't get it. You can't get a professional engineer to do that. So what I'm saying is just what I said. Your comp plan's wrong. Finished floor elevations are wrong. Taking out the trees. So I'm asking you to do something about it. some kind of recommendation to city council, city manager, something, to do what you're really hired to do, and that is to use what's available to you, and that is professional engineers. Get their the facts and so forth to do it. That's all, and I'm here to questions. Thank you.
Thank you, sir.
I have a question. In reference to Park Preserve, you're talking about the corner of Park and National McRae, right?
Yes, sir.
Now, that's the staff. The tree ordinance that existed when that was development, probably 2 years ago, the development started at Park Preserve. Is there any indication of the survey of trees in that location and a survey of, protected species in that location?
That's a site-specific project that I'm not prepared to answer on tonight. If you send an email or if you want me to follow up, we can do that. I just don't have the information tonight.
I'll give you plenty.
Certainly, I'm aware that one of our members was the engineer on that project, so if Mr. Rice wants to answer the question, he can. Yes, Mr. Rice.
Okay. Yes, I am the author. And yes, did it follow the code of ordinances the city of Titusville did? Did the developer receive a development order from the city of Titusville saying that it met the code? Yes, they did. Did we preserve 4.87 acres of forested wetlands and trees on the site? Yes, we did. Okay, that was allowed by code. Okay, I followed the code. Having sat through a little shy of 5 hours in TEC on proposed new ordinance for trees, does it meet the standard that some of the people in the community would like to see us go to? No, but it wasn't required to meet that. Okay? If you want disbursement of trees throughout a subdivision, then the code needs to address that. At the time that this was approved, at the time that development order was issued, it met the code of the city of Titusville. So
how about the second question?
What's the second question?
Endangered species.
There was a tree survey done.
No, I'm talking about the survey of endangered species, like the gopher tortoise.
Yes, there was an environmental report that was done on the site.
Okay, thank you.
Okay, thank you. Thank you, Mr. Rice. Nothing accusatory, what was done.
Okay, anyone else under petition to request from the public?
Yes, Ted Gerard.
Yes, sir.
Block. The purpose.
That's better.
Thank you. Ted Garrod, for the record, 124 Park Lane. I didn't get my address, Titusville, Florida, earlier. Earlier, I presented what I wanted to try to solicit from the commission, and due respect to Mr. Severson being an attorney at law, is that these ordinances upon adoption can have adverse effects, and they can be extremely expensive adverse effects on vested rights and nonconformities. Staff will have to wrestle with what's the extent of a nonconformity and how long do you cease a nonconformity. And the world we just left was a world that closed things. Lots of businesses went out of business. I would subject that you would have a business possibly closed with outdoor seating, and having your rule proposed as it is, the new owner tries to open it a year later and gets told, I'm sorry, you'll have to come to a conditional use, and et cetera, falls out of that. So when you affect existing, you have to pay a lot of attention to nonconformity protection and vested rights. I believe it would be helpful too tonight. I heard a lot of comments, but all of it focused on the outdoor seating to noise, abatement of the noise by distances, abatement by noise through techniques. It didn't change that people sitting outside without amplified sound, screaming at 11 o'clock at night, making noise and waking neighbors up, isn't unaffected by that because it's not amplified. And the last part of this is that in the case of mapping as your distances Mr. Rice was concerned with, and that's very cute of you to see what happens with sound and sound pressures and doubling of decibels and all those good things that take place with certification of sound measurement. The question is What does it do to the existing places? You should see that. Have your staff in the time they have available, maybe it does take 2 months, to map that, show you those distances, show you what happens to all these existing restaurants. I frequent a lot of restaurants in Titusville since I retired. I love it. I enjoy the outdoor seating. Mr. Rice, I think you would agree. And the fact of the matter is, there's very few examples. They're existing, and they're all about the same, other than what's existing in downtown, as I mentioned earlier in my presentation, of the effect of impedance of sidewalks and all those things that probably are nuisances to people and create complaints. But in the general, by and large, area of these outdoor seated restaurants, they exist. When I looked at them, it's going to be kind of difficult for them to meet these criteria, not have the noise exceed the decibel, measured at the boundary, and measurements taken, which you incurred, that would be a code enforcement issue, not exempted by your conditional use. The rules are rules. So sometimes the saying is less is more, and this proposed rule may be an example of more is not necessarily better. It may be complex, it may be confusing, it may be contradictory, and you already have existing rules on code that would assist you in those matters without adversely affecting or creating nonconformities that aren't anybody's friend. Thank you for allowing me to speak.
Thank you.
Have a good evening.
Next is reports. We have city council summaries, 2 of them. Any comment by staff concerning those? No? City staff, any comments?
I'd just like to say that since Gabriel Quintus left, that I promoted to senior planner, so I'll be your new P&Z liaison, staff liaison. My name's Eddie Galindo. I've presented to the commission several times before, but just wanted to formally introduce myself and looking forward to getting to know you and working with you in the future.
Welcome aboard, sir. City attorney.
As I've said at least twice earlier this evening, I wanted to let you all know that there was a request at the last council meeting from a member under petitions and requests. A member of the public asked for city council to look at the sale of alcohol hours, because there was a request to buy alcohol before 7 a.m. on Sunday mornings in order to go fishing. So that was the premise of that request, in addition to the Brevard County Commissioners having their discussion regarding that ordinance change. The second item that I'd like to tell you all about is, some of you may have been present at the TEC meeting that recently took place, 5.5 hours long of discussion on trees. I was not there, so those of you that were, thank you for attending and participating. The Planning and Zoning Commission has asked for a schedule, and the planning staff has told me that May 5th, the next meeting, is when the Planning and Zoning Commission will hear the tree preservation ordinance, and the City Council will hear that item on July 27th.
So Chelsea, it in essence gives us 2 months between the first meeting in May and when the council discusses it in July.
I can't tell you how they came up with that schedule, but I wanted to let you know that that schedule was provided to me, but that's what it sounds like. Eddie, do you have any further comment?
Just to elaborate, the reason is city council typically cancels the last meeting in June. Thank you. And so there's an extended gap between from when P&Z hears it to when city council will hear it.
Will Peggy Busaka be present at our meeting?
At the P&Z meeting?
Yeah.
I don't believe so.
Well, I make a motion that we request she be at our meeting when the tree ordinance is discussed.
Is there
She's been involved in that since the beginning, almost 2 years. And I think we should ask her, not require, I'm just saying ask her to be present.
is the concern that current liaison staff would not be able to
Well, she's been involved in it since the beginning.
Okay.
She was involved in it, and Gabriel was partially involved in it, and he's not here anymore.
Sure.
So I would make a motion this commission ask Peggy Busaka to be present at the meeting May the 4th, did you say?
May 5th.
May 5th, that we're discussing the tree ordinance.
Is there a second to the motion?
In a motion, can't we just relay a request through the staff?
We could.
I would prefer it just be a request as such.
We're not requiring it.
No, we're just asking that it be at our meeting.
Yeah, a strong request.
I'll go with that language, strong request.
Okay, so you've heard Member Richardson, strong request, such from the commission. All right, anything further from the city attorney's office? I was going to ask why the long delay, which is a long delay from May 5th to July 27th, but time's going by. Anything else from city staff or the city attorney's office? Under chairperson's report, I had a couple of things. I've mentioned this to a couple of people. I think at some point in time, either the old podium or a larger podium be available to those who present to us, because that setup does not work. If you bring a file up there, there's no place for your papers. And whether you're a engineer trying to make a presentation or an attorney trying to make a presentation, it's impossible. And I don't know why. I don't know what happened to the old podium, but certainly that impairs the ability of people to speak and give credible information and refer to their materials and open a file folder, etc. You can't even put an 8 by 12 sheet of paper up there because the speaker thing is in the way. Secondly, with regard to the tree ordinance, I know it's coming up May the 5th. Will the staff be presenting the action or recommendation from the from TEC as such? Okay. And I know we do have Mr. Rice here on TEC, the liaison. I would suggest that perhaps staff make its presentation first, and then Mr. Rice could be somewhat prepared to supplement what staff says the T recommendation, if that's all right with the commission. I think we need to hear those two things up front, then open it up for the public hearing as such.
Yes, it was a long night.
Yes.
It was very healthy discussion that we had with the community. There was a lot of speakers at the site. Eddie, you did a great job. Okay. I next P&Z, you definitely have to be here. Okay. Because you know what was said at TEC, took all the notes, you did everything for that meeting. So I think you're vital to, to our next discussion. I'll be happy to try to fill in any gaps that we have. I think one of the directions that I asked staff to do was to try to put it in a format for P&Z, showing staff version and the TEC action. We would add P&Z actions, then city council has in front of them sort of the direction staff TEC to P&Z, because it's a lot of information.
Yes, sir.
That's a lot of information. And they did something similar to that probably a year ago, where they had an Excel spreadsheet with the different versions, differences between. And I found that to be a really useful tool. So hopefully we'll have that at P and Z showing staff ordinance, TEC action. And I will tell you at TEC adopted the TEC version as their baseline, then made changes from that point forward. It did not use the staff version.
Okay. Well, as I see, because of the timing, there's not necessarily a rush at the May 5th meeting that we have to come up with our final recommendation as such. As Bryce just pointed out, there's a lot of important discussion. Probably a lot of input will be received on this. We need to make sure that we're considering it and give appropriate ultimate input to staff and council as far as our position on it. Remember, Riley, where you were next. Did you have anything? Yes, sir.
It has to be, because there's just way too much information to get through. I understand.
In that regard, is it the desire of the commission perhaps to start at 5:30? Or even 5 o'clock? What's your desire? What's the desire, either 5 or 5:30? I hear 5:30. Okay, so we'll do that, 5:30. And move it up a little bit.
So
I was present at the...
I'm looking at the agenda, and it looks like there's two things on the agenda. There's a comprehensive plan amendment, and for advertising purposes, we'll just need to know what... And then the other item is the tree protection ordinance. And so we'll need to know what time to advertise the hearing for the comprehensive plan amendment. We could workshop the tree protection ordinance at the beginning and then have the meeting start at 6 if we want to have a workshop hour for the tree ordinance.
I just call it a regular meeting and just advertise everything at 5:30. Unless the ad is already run for the other ordinance, and if it's already run, we'll stick with that. And that brings me to then, I was present for a portion of the TEC meeting. I think it's my intention, unless I'm overruled, to allow 5 minutes and 3 minutes. Difficult to cover a 15, 20-page ordinance by individual 3 minutes. And matter of fact, that's what TC is. So I think that's a advisable thing to do. That's my intention at this stage. In addition, I would, one of the most recent subdivisions that's been cleared, which is indicated that is in compliance with the current code, is the Brookshire subdivision on Garden Street across from South Lake Elementary and runs all the way over Carpenter Road. I would strongly encourage everyone to see what staff is saying the code currently allows. And further in that regard, and staff can do this if you want to or not, I think it's very helpful to the Planning and Zoning Commission. We have various subdivisions that have been reviewed under the current ordinance, such as Forest Trace, Park Preserve, Brookshire, South Carpenter. I can keep on going, Willow Creek. I think it would be good to have some examples. Current code is allowed, and what this staff version of the code, how that affects it or impacts it, to see whether or not we are making any real changes or meaningful changes. Now, maybe you don't want, that's up to you whether you want to do that, but I will be myself. I have pulled the tree site plan or tree information on most all of those I just mentioned, so I'm aware of the 109 trees that were 20 inches in diameter or greater at Forest Trace, and how many of them were of what size, and perhaps how many of them can be automatically removed, etc. So I think it's a valuable information to all of us to see whether or not we're reviewing and drafting an ordinance and the impact of that ordinance, so that we can decide whether or not we're going in the right or wrong direction. That's just a suggestion as such. One other provision I just want to indicate to the city attorney's office. I know there's been a lot of discussions about the grandfather provisions, what are under the old ordinance and what under the new ordinance. The law may certainly have changed, but I was well aware in many cases on point whenever an ordinance was in draft form and fairly well known to the public, the developer or developers are on notice of it, and so if it's subsequently enacted and they have not pulled all their permits, have a building permit, etc., it can't apply. So I'm going to be asking those kinds of questions because you have a lot of people in this community that are not very happy because the direction to staff prepare this ordinance occurred July 19th, 2019. Council is not going to consider the first ordinance till July the 27th, 2021. And I've attended the community meeting and other meetings whenever been talked a lot about, well, 1,000 and some homes have been approved. And there's 3,000 or 2,000 more homes on the drawing board. And there's a lot of concern as to whether or not so much time has gone by, we have lost the opportunity to have a meaningful ordinance that does protect trees, protects our environment. So I'll be asking those kinds of concerns, questions, because that has been an issue that's been raised by a number of people as far as the 2-year time delay before an ordinance even is presented to council public hearing. And the last item I wanted to mention, because it's in the minutes, our meeting that we last had on March the 17th, at the end of the meeting, Chairman Seaver said he would like for the Planning and Zoning Commission members to be prepared for April 21st, 2021, with a list of priorities that the Planning and Zoning Commission may feel should be addressed by the Commission on future agendas. Since we did not have a meeting weeks ago, I would suggest we just defer that, don't take that up at this meeting, but not on May the 5th, but the meeting following that, I would suggest that this be an agenda item, much like TEC, I think, is discussing outstanding issues and priorities. I think the Planning and Zoning Commission should do the same thing. And so just keep that in mind. That's all that I have. Member Grant, do you have any report?
No, sir. Getting back to question concerning TC, I'm not sure who was responsible for it, but I received a transcript of their meeting, and I like to say it was very informative. I liked it very much. It's almost like being there while the meeting was going on. I wish I could, receive it, that kind of transcript all the time, but I'm not going to request that. But I just wanted to say it was very, very helpful. It was.
For your information, that was a member of the public, Ms. Kay St. Ange. She's very passionate about it, and I'm sure she'll be here during the tree discussion, so you'll be able to thank her personally then.
Yes, she is. Her passion is overwhelming.
Member Porter, any?
No report from me.
Member Spidell?
Berkshire Development maybe take a bill before they do so. I am horrified. It is destruction. It's just, and I too am very concerned about 2 years of stalemate in developing. When I'd like any more development or in the making. Sure that this delay is a danger supply. Clear cutting.
I appreciate, Member Spidell, your comments on that. In addition, please remember that on that particular track, there's been 8 feet of elevation change, number of locations. Well,
I understand.
So that's another major issue. And Member Price, any reports?
No, I think we've covered TEC.
Okay. Member Richardson.
Yes, Mr. Childs, would you hand those out to the? I'm not good at spreadsheets. I only have one finger that can operate. This is what I heard today on the Titusville talking points on the YouTube video. They discussed 25 developments. And it's incomplete because, like, for example, the Horizon development, which I know Woody can address, it didn't give us a total number of units there. But this is what was in today's talking points. These 25 developments. If you see yes and no under trees, they had to take out some trees. I don't know how many. And then soils, was there an adjustment in the level of soils? Some of these are much to my surprise. I've not heard of this. For example, Launch Credit Union is developing a parcel next to Walgreens on Garden Street. You're aware of ViStar Credit Union. Hope Hammock is a small development on the corner of Palmetto and some other street. Wendy Lee Condos just came out of nowhere. Bragg Company is developing a 9,221 square foot warehouse and office complex that we've seen nothing of. Alpha Omega Training and MJW Consolidated. And some of these, like the ones, the MJW Consolidated and Alpha Omega Training and Lockheed Martin, they're building a 179,000 square foot building. All of this is going to impact the trees in the industrial park. And I just found it stunning. I was sitting there eating my yogurt and drinking a Diet Coke at 4 o'clock in the morning and ran this YouTube. And I spent the next 2 hours putting this dumb-looking spreadsheet together because it really appalled me to a degree. And I've gone by not Brooks Landing, the one we were talking about before, Brookshire, twice. And I went by there 2 weeks ago, and I was appalled at what I saw, just like Member Spidell said. And then I went by this weekend, and I was not appalled. I was angered. There'd been more trees taken down. And understand that somebody in the community has flown a drone over it. And I'm not convinced they met the code. And because my family tried to sell their house, well, successfully sold it, but a single family house, a gopher tortoise was present. That gopher tortoise relocated would have cost them $2,500. There's no telling how many gopher tortoises were present. They're an endangered species on the Brookshire subdivision. Trees, one of them 46 inches in diameter, were taken down. If you haven't gone by there, go by there. It's worse than bombed out Iraq. And I've heard a lot of criticism and questions from the public at large about that. But we've got this going on all over Titusville. Recently, the development along I forget what we're calling it now, 407 or something like that, South Street. They went in and it looked like they bulldozed everything. And, you know, why it's taken 2 years to get a tree ordinance passed in the city of Titusville, there is no excuse. There is no excuse. And I think it's almost like I'm suspicious that these developments were pushed through as fast as they can. And the tree ordinance was delayed. Because all this new development, this is just this month. This is just this month from the city's public relations department. At least, and more than that, 812 units. At least 280,000 square feet of commercial and office development and retail. I'm not opposed to any development, but I remember a certain candidate who is not on council at the present time. His slogan was, he's for smart growth. Well, I don't think I'm seeing it right now. This growth is not that smart. And I agree completely with what the vice chairman said about Brookshire. Just go by there. Not only along Carpenter, but drive up, I think it's West Lake or Westview or something like that. And take a look at it. Is that what we stand for? That's all I got to say.
Member Childs?
No, sir.
All right, Member Riley?
Just want to comment on what Commissioner Richardson said. And the way I look at it is all of that is terrible, but we have to go forward. And it's on us to get our act together on May the 5th and get it done. Because we can't undo what's been done, but we can definitely do something about the future. And we can give the package to City Council on May the 5th. And hopefully that will be, will it be ending for us on May the 5th? Mr. Severs? Do you think that that will be our final product on the? No?
No. But we need everybody's input. I foresee we having at least 2 or 3 meetings.
Really?
And we have the time.
Say it.
We
I
have
bet
the
you
time.
goes on for another 3 or 4 months.
What we need is low impact development. We need an ordinance.
Looking at a small little lot with a heritage tree right on US 1 that already has the plastic stuff around it. There are several. I think there's more than one heritage tree on that lot. And I think that's a proposed gun place, more guns. Does anybody know, the staff know what's going in? US 1, the small lot.
Fine, Ida.
Woody
can tell you
I
about
can
that.
tell you already.
What is going in there? Woody?
It's a professional office that's going in there. They bought it from the people that,
Okay.
okay. It's the first LID development that has been permitted in the city of Titusville, out of LID ordinance, okay? It was very hard to permit because there was no ordinance, and I tried to do everything. I saved 82% of the oaks. Maybe it was 72%.
Isn't
Like
there a heritage
of
oak on
oaks.
there?
No, there was no heritage oaks. The biggest one was, the biggest ones are 24-inch, and they're
There's
up
some
front,
big
and
ones in
I saved both of those.
Thank you.
Okay. There was 2 that no matter which way I put the building or the parking, I could not save. So only two mitigation sized oaks, okay, I could not save. But I saved, and I have the numbers, I saved, like I said, 72%. I got a variance to try to save one, which was granted by the city. I did administrative waivers to save them. So I used pervious concrete to make sure that we were doing, there's not much percolation into the soils in the root zones. Actually, I tried to keep everything out of the root. I did bioretention gardens, okay, that then drain into a dry pond. And so that's the development. It is a small professional office. But I was, I have to commend the developer because they convinced me. And they liked the idea. And I did my darndest to work with city staff and try to do something without having an ordinance written for LID. And I think staff learned a lot. I learned a lot of how we maybe can craft better LID because I've been through that process.
I just used it as a very tiny example, but when you look at this list, and you count the number of houses going in, there's going to be a tremendous sale of, what are those little pink trees that people put beside their garage? Yes. All buy stock in the pink tree.
Well, okay, we're about at that hour. I'm going to close by something my wife asked me, and it's dangerous for me to do that. But she said, why in the world is the city allowing the destruction of all these trees? She used Brookshire as an example, but on the other hand, for Earth Day is offering 1,000 little bitty trees free of charge for any citizen. Why don't we just save some of the large oak trees it's sort of ironical, staff, in a way, what's going on. And with that, we're adjourned.
Thanks for watching the Titusville Planning and Zoning Commission meeting. Coming up next, the Florida Channel, already in progress.